we would discuss the leftover legal ingredients to determine the very concept and idea of equality. So, the equality doctrine, as propounded in the leading case, Passions Agrotech versus Union of India in 2015, Supreme Court expressed the very equality doctrine as once it is found that there is sufficient material for taking a particular policy decision, bringing it within the four corners of Article 14 of the Constitution, the power of judicial review would not extend to determine the correctness of such a policy decision and to indulge into the exercise of finding out whether there can be suitable alternatives, as it was determined in this leading case, Passions Agrotech versus Union of India, and the next legal ingredients to determine the very idea of right to equality is equal protection of law, as it was pronounced in the leading case Anita Khushwa versus Puspa Sudan in 2016 by the Supreme Court. So, as it was pronounced by the apex court in this leading case, Article 14 of the Constitution of India mandates that state action must not be arbitrary and discriminatory. It must also not be guided by any extraneous consideration which are antithetical to equality, as it was pronounced by the Supreme Court. The equality before law and equal protection of law is not limited in its application to the realm of executive action. It is also available in respect of proceedings before the courts and tribunals where the law is applied in the interest of administration of justice, as it was declared in this leading case Anita Khushwa versus Puspa Sudan in 2016 by a apex court. And now we'll go to the next legal ingredients, and that is rule of odi alterum partem, as it was declared by our Supreme Court in Manohar Manik Rao versus State of Maharashtra in 2013 by our Supreme Court. It was expressed that hearing the parties' application of mind and recording of reasoned decisions are the basic elements of natural justice. The adjudicatory process essentially has to be in consonance with the principles of natural justice, including the doctrine of odi alterum partem. And now we'll go to rule of bias, as it was declared in this leading case, State of Gujarat versus R.A. Mehta in 2013 by our Supreme Court. as it was pronounced, the doctrine of bias emerged from the legal maxim nemo judex quasua. The bias is one of the limbs of natural justice. The apprehension of bias must be reasonable. If such apprehension exists, the trial, judgment, order, etc. would be initiated for want of impartiality. It applies only when interest attributed to an individual is such as to tempt him to make a decision in favor or to further his own cause, as it was decided in this leading case, State of Gujarat versus R.A. Mehta in 2013, and now will discuss another legal ingredients, and that is concept of equality, and as it was decided by our apex court in the leading case Casta Nivakar versus Indore Development Authority in 2006 by our Supreme Court. So, the concept of equality cannot be pressed to commit another wrong, as it was decided in this leading case. And now we will go to the very concept relating to procedural discrimination. So, the very concept of procedural discrimination, as it was pronounced in the leading case Chopra versus Union of India in 1987 by our Supreme Court. So, according to the apex court, Article 14 forbids discrimination in matters of procedures. So, now we'll discuss regarding the other item that is falling under legal ingredients, that the different procedures adopted for larger public interest, and as it was decided in the leading case Girish Kumar Suneja versus CBI in 2017 by our Supreme Court. So, as it was decided that in the matter of coal block allocation cases, a different procedure has been adopted in larger public interest as well as in the interest of the accused is not discriminatory, as it was decided in this leading case, that is Girish Kumar Suneja versus CBI in the year 2017 by our Supreme Court. And the next one is that another legal ingredients to determine the very concept of equality or right to equality, as it was pronounced in this leading case, State of Uttar Pradesh versus Committee of Management in 2010 by our Supreme Court regarding discrimination. So, discrimination, as it was pronounced that action of state creating class within class violates Article 14. So also, where a challenge is made to a statutory provision as being discriminatory, the allegation in the writ petition must be specific, clear, unambiguous, and there must be proper pleadings, as also it was pronounced by our Supreme Court in the very leading case. So also, if the differential treatment relating to water charges is given to industries using water as raw material, it would not be discriminatory. So, also it was decided in the leading case PepsiCo India Holdings Private Limited versus State of Maharashtra in 2011 by our Supreme Court. So, exactly it pronounced that where it is differential treatment relating to water charges given to industries using water as raw material, it would not be discriminatory as it was decided in this leading case. So, why exactly interpreting what is right to equality and what are its scopes and jurisdiction and its application? And now we'll discuss another legal ingredients, and that is on canalized discretion, and that on canalized discretion, and it was expressed or declared by our Supreme Court in relation to Delhi Transport Corporation versus Mazdoor Union of Delhi Transport Corporation in 1991. So here it was declared on canalized discretion vested in an administrative authority is not permissible. So this was how the apex court expressed their views in the form of exactly explaining what right to equality and how far it could be extend and into what areas. So also now we will go to the very idea of arbitrary actions in right to equality, why its implementation and such arbitrary actions and how it would be considered as discrimination. So, regarding that, you will see the very arbitrary action that is leading to discretion. So, where legislation which gives a wide power to the executive to select cases for special treatment without indicating the policy may be set aside as violative of equality On the one hand, provisions which lay down policy are likely to be upheld, but on the other hand, provisions which lay down policy are likely to be upheld, but on the other hand, provisions which fail to give such guidance are likely to be invalidated. And relating to that also, another pronouncement of this particular leading case that was relating to the very important leading case, Sri Sitaram Sugar Company Limited versus Union of India in 1990. Supreme Court expressed that any act of repository of power, whether legislative or administrative or quasi judicial, is open to challenge if it is in the conflict with constitution or the governing act or the general principles of the law of the land, or if it is so arbitrary or unreasonable that no fair minded authority could ever have made it. And now we'll see exactly very scope of Article 14 as relating to determine exactly the very scope and jurisdiction of Article 14. So, regarding the very scope of Article 14, exactly we'll discuss the most important or the famous case Indra Sahani versus Union of India in 1993, and in this very leading case it was decided that Article 14 is to be understood in the light of directive principles, as Article 14 guarantees equal treatment to persons who are equally situated. And now we'll see the very provisions relating to the very question of test of equality. And in regarding to test of equality, we found there are a number of important leading cases such as D.S. Nakara versus Union of India in 1983, which was decided by our apex courts also. Pradeep Jain versus Union of India in 1984, decided also by our apex court. So also Atma Prakash versus State of Haryana in 1986, and the last most important leading case relating to test of equality is K. Thimappa versus Chairman Central Board of Directors, State Bank of India in 2011. The Supreme Court expressed the determining the validity of statutory provisions. Courts in India have followed the general principle that equal protection of the laws means the right to equal treatment in similar circumstances. Courts have upheld legislations containing apparently discriminatory provisions where the discrimination is based on a reasonable basis. By reasonable, it is meant that the classification must not be arbitrary but must be rational. So, this was the gist of those legal ingredients which determines the very scope and jurisdiction of right to equality, as these are determined and pronounced by our apex court. And lastly, this very test of equality finally justified the very areas of its operation and determining the reasonableness, the rationality, and the justiciability of its application either by the legislature or by the executive or any administrative action so relating to judicial or quasi judicial actions.